Hello and welcome to the Legal Broadcast Network. I'm Vanessa Pang. Today, Mayo, founding partner of Mayo in Poland in Baytown, Texas, is joining us on the phone. He'll be talking about the costs to consider when negotiating a settlement. Mayo in Poland is dedicated to serving senior citizens, people with disabilities, their families, and advocates, including the preservation of personal injury settlements. Pi is a former president of the Special Needs Alliance, a national organization comprised of disability attorneys. Pi, I want to start off by going over how serious injuries can affect victims and their families.
Damages from a lawsuit for a personal injury can be very, very traumatic and very, very expensive long-term expenses for people. Some cases that's not true, so you can't generalize across all cases. You have to know very important specifics about, number one, the age of the person when they were injured, the severity of the injury, and whether they're expected to have a rehabilitation time and get better or whether the injuries are permanent. Secondly, after you determine the lifespan or the time span of the injuries, you have to determine whether they have a negative effect on that person's long-term earning capacity. If they have a negative effect on the person's long-term earning capacity from a small amount all the way up to they would be considered totally disabled, that also can have a tremendous difference on the impact on the family. In addition to that, how important that person's earning capacity would be to their family. In other words, some persons might be a house husband or a housewife, and they are going to earn a secondary income to their husband or their wife, or they may not be married. They may be their only source of support. They may have dependents that they're supporting, like their own children, maybe even their parents. All of those things can go into an evaluation of how dramatic the impact is on the family.
But what about when it comes to forecasting expenses that come up down the road?
Well, once you've made some inroads and developed the information that we talked about in the earlier part of this question, you can then use that information to project into the future either how much money this person might make or how much this person might not be able to make based on their diminished earning capacity. But always in a lawsuit situation, because of the nature of the proof that's required in a lawsuit, and we're talking about lawsuits here, so we have to keep that in mind. Almost everything we talk about is dependent on what would happen in a court of law. Now, the majority of these cases are settled by the way of settlement, but the settlement's going to reflect what would take place in a courtroom if the two sides were to go into court and duke it out. So you always have to preface any of your discussion with the other side in terms of settlement with evidence that would be admissible in a court. Now, for predicting things like the person's lost earning capacity or future medical expenses or rehabilitative aspects, the only persons who can testify in court about those things are people who can qualify as an expert. And in both in state courts and in federal courts, there are specific requirements of the rules of evidence as to who can qualify as an expert on those matters. Because only someone qualified as an expert can give an opinion about a subject matter like how much a person's going to earn over their lifetime. So you always have to consult experts in these areas or these fields to make these determinations. For instance, you'd want to start out with a life care consultant if this person has injuries that are expected to diminish their life expectancy. And then you would have to have an expert testify to the future medical needs of that person to develop the cost of those future medical needs. You do not have to have an expert to cover what medicals they've already had in their past, but virtually everything that you're talking about when you're talking about dealing with a person's future projected expenses, earning capacity, life expectancy, future treatment especially, because many, many times you have someone that's going to need an operation 2 years from now and they need another procedure done 4 years out. In addition to that, you have medical expenses for durable medical equipment. If someone has a prosthetic device or a wheelchair, they may need that wheelchair replaced when it wears out. Their prosthetic device may wear out. In addition to that, there may be surgeries that are going to be involved in changing components of their prosthetic devices and things like that. Those all require expert testimony, so you have to consult an expert in order to deal with those issues.
All right, shouldn't public benefits, though, such as SSI and Medicaid, cover costs for personal injury victims?
Once again, when you're talking about this and you're talking about trying to settle a case outside of a courtroom where there's not a jury verdict returned, the other side is always going to want to minimize what the expenses of this person are going to be in the future. So one of the ways they can minimize their exposure or their liability is to try and prove if this person needs an operation down the road, that some other entity would be responsible for paying for that operation, like private insurance carriers or Medicaid in some cases or Medicare. So the defense component, or the other side, the person who is being sued and is being asked to be held liable for these expenses, is going to try to bring in all kinds of outside possibilities of payment for those expenses, and to show that those expenses are not something that should be covered by a defendant in a liability situation. Now, you always are asked about Medicare and Medicaid in situations where people are either eligible for one or both of those programs. However, it's important to note that in a lot of jurisdictions, and you can't escape this point in a lot of jurisdictions, that's what's called a collateral source. And in many jurisdictions, a defendant is not allowed to decrease their liability for, say, future surgeries by saying, well, this person could get Medicare to pay for it, or they could get private insurance to pay for it. That's called a collateral source. And the reason that's not allowed is that just because you happen to have a car accident and the person you happen to run into and hurt happens to be on Medicare, that doesn't necessarily decrease your liability for future medical expenses of that person, because you can't pick your victim, so to speak. So whether or not they have Medicare or Medicaid or private insurance paying expenses down the road can be something that the defendants will often want to bring into a negotiation, but you have to know in a lot of jurisdictions that evidence is not allowed into the courtroom, so therefore it shouldn't be something that's allowed in the settlement negotiations. Now, on the other side of the coin, the plaintiff side may be seeking to look at what that's going to do for their client, because if you have catastrophic injuries, tremendous pain and suffering, and limited resources on the other side, say the defendant has limited insurance coverage, or they don't have any insurance coverage, the amount of money that you may seek to recover may not be enough to make your plaintiff whole. Well, if you can't get that person's medical covered by some other entity, then it may not be possible to get the plaintiff to accept a settlement that on paper is not going to make them whole. So sometimes the plaintiff's side of the case, or the plaintiff's attorney, is going to want to know, well, can he show his client where if we settle the case for this amount of money, that's going to be enough to pay for future needs of this person, because they can qualify for some other type of medical care. From it could be even TRICARE if they were in the military, or it could be Medicare, it could be Medicaid. So it can go on both sides of the equation. The defendant wants to use those other collateral sources to reduce their liability, and in some cases the plaintiff may have to look at it that way as a way to reduce the future liability that they're going to have to pay for, and settle for a lesser amount of money than would cover all those expenses plus their current expenses, pain and suffering, and lost earning capacity.
What about liens and claims on settlements?
That is a very, very complicated matter. And the reason is because each individual claim holder or lien holder doesn't always, in most circumstances, a lot of hospitals will not assert the totality of their claim. In other words, if it's a hospital and they know the person's injured and there's going to be a recovery, they may agree to take a small portion of the amount of money that they're actually owed, because as everybody knows, when you go to the hospital, if you have no insurance, there may be $1,000 fee charged for a procedure. But if you have medical insurance or a health maintenance organization, an HMO, they may have negotiated in advance with the hospital to say, we will only pay you $150 for this procedure, and the hospital, for whatever reason, agreed in advance to take that. So when you have a claim from a lien holder, because hospitals are generally have liens to secure the bills that they incurred while they were treating you in an emergency basis, the first question is, what did that cost? And sometimes that's a kind of a moving target. You may say, well, it was only $150 because if I had insurance, that's what my insurance would pay. But then the hospital may assert, well, no, we charge someone without insurance because we didn't make a deal with you prior to you becoming injured. That procedure is going to cost $1,000. So there's a lot of leeway in there in how much hospitals and doctors charge. Secondarily, it may be a realization that the hospital knows, based on what the damages are and that sort of thing, that they're not going to get the totality of their money. Let's give you an example. If the hospital has a claim for $100,000, and because of what we talked about just before, the defendant who's being sued only has $80,000 in insurance coverage. And no matter what else happens, if you sue and win a huge, say the settlement, the judgment's $1 million, the most you're ever going to get out of this defendant basically is about $80,000, which is their insurance coverage, unless they have other assets that could correspond to or respond to a judgment. So the hospital has to look at that and say, okay, the plaintiff is the one who has to file the lawsuit and pursue it and get a lawyer. If we say we're going to take $80,000, the whole amount, because that's what we're owed, because our bill or our lien is for $100,000, then the plaintiff's not going to go sue anybody or do anything because they're not going to get any money out of it. So they have an incentive to reduce their claim enough to make sure that there is, if you want to call it leftover money, that doesn't go to the hospital's claim, so that it would entice, if you want to use that word, entice the plaintiff to pursue the action. Otherwise, the hospital is kind of hung out to dry because and it happens a lot of times, people just decide for whatever reason they don't want to sue someone. And if there's no other else medical insurance to respond, or Medicare or Medicaid's not covering it for some reason, then the hospital's not going to recover anything in that standpoint. So claims from third parties like hospitals, doctors, and many, many times if a person has their own private medical insurance, their medical insurance will cover the procedure they're going to have or the emergency room bill and that sort of thing. But the contractual agreement between the individual and their insurance company says that their insurance company is what's called subrogated, which means they get to step in the shoes of the injured person and go after the money themselves that is owed by the defendant. And in those cases, the plaintiff normally doesn't have much of a choice because they didn't pay the bill out of their pocket and they're not responsible out of their pocket because their insurance company covered it. And the insurance company gets to go after the bill. But the biggest consideration is if you have these outstanding claims out there and the defendant wants to offer a certain amount of money to settle, is there going to be enough money to make the plaintiff whole and also to cover those expenses? I will tell you in most instances nowadays, unless you have a commercial defendant like a business, say like some business entity like a Coca-Cola company or a utility company that's the person who caused the injury and has some large insurance there to cover that loss. If it's an individual, then their ability to respond to a judgment is going to be limited to their insurance amount. And if somebody's dramatically or drastically injured, they're going to have a really hard time covering their pain and suffering, the loss of their future earnings, and pay all those medical bills back. So that's why those medical bills and claims from other entities, including your own insurance company, the subrogation claim we talked about, has to be negotiated down so that the plaintiff is made whole or as much whole as they can be made before any of those other guys get any money, and then they are going to take a discount on what they're owed because otherwise the plaintiff wouldn't get any money out of their claim.
Also, can you touch on expenses that are incurred while victims are awaiting a settlement?
That goes over into the overall expense or cost of the settlement right there. Many, many times we briefly went over the fact that there could be huge medical bills already out there that have been incurred that are owed before we even get started negotiating and settling a claim with someone. But in addition to that, if you have a person who's drastically or dramatically injured and they were working at that time, they may have had some savings and stocks or bonds in the bank or whatever, but they may have plowed through and spent all those because during their period of time when they are trying to get better and go through the procedures that they may need to go through and rehabilitate themselves, they haven't been able to work. And they may have used up a lot of their savings, or what you see most often in a lot of cases is people are using credit cards to live off, basically. So they may have some huge credit card bills outstanding due to their loss of wages while they were ill or while they were hurt from the accident. In some cases, the same people, they may take out loans to finance, their rent and their house payments and those sorts of things while they're going through the litigation. And most time, these types of litigations can drag on in years in some instances, depending on how large the lawsuit is and the recovery and the damages on either side and how clear the liability is. If somebody's really fighting on the other side to say that we weren't responsible for the accident in the first place, then that can take many, many years. So before you even talk about paying for the medical bills that person's incurred, that money going to third parties like hospitals and doctors, that person may want to make sure that they're made whole, and they have to face those credit card debts that they've accumulated or the loans that they've accumulated. If the injuries are dramatic, then they may have had to pay for attendant care to help them rehabilitate themselves, or to have help with activities of daily living like dressing themselves and bathing, those sorts of things. So they may have run up a huge debt with that type of care, or that may have been what caused them to exhaust all their savings. So paying for the expenses that have been incurred up to the time of settlement is just another big factor, just like paying for future medical and future operations are. However, in some instances, no matter what else happens, if there are no monies to pay for future medical expenses, those future medical expenses could be covered for things like Medicaid, Medicare, or private insurance. But you're not going to get any coverage from anybody like Medicare, Medicaid, or private insurance for those living expenses that person has had in the past. So those living expenses that they've incurred and ran up debt on have to have been covered somehow or another in the settlement with settlement proceeds. And that's when you start getting into this issue that there's just not enough money to go around. We got to start out with paying the debts that we've incurred. Then we got to look at how we're going to live in the future, how we're going to pay for our next medical procedure, and then how are we going to pay back the doctors and hospitals that we're owed now. It's a fact of life that a large percentage of the bankruptcies caused in the United States today are caused by medical expenses. And generally, those expenses can happen in most instances when you had a catastrophic injury and the person does not have their own medical coverage. There may or may not be enough money from the person who injured you, from the liability defendant, to pay back all that medical and all those expenses. And that is a major cause of bankruptcy in the United States today.
Pi, thanks for your time today.
Thank you for your time. I appreciate it.
And thank you for watching the Legal Broadcast Network.